So the first thing I'd like to know is whether or not the media is in fact in the courtroom.
Yes.
Yes, what?
The media is present.
We're on the record, Your Honor.
We are on the record in the matter case D21. I believe we have the plaintiff's side appearing by video.
Yes, Your Honor.
Go ahead and let's confirm appearances.
Good morning, Your Honor. Shannon Wilson, bar number 9933, on behalf of plaintiff in member capacity. She is appearing separately via Zoom.
Good morning and welcome. I have the defendant here in person.
Defendant appearing in proper person.
Good morning. You're welcome. And confirm your appearance.
Good morning, Judge Amity Latham, Chief Deputy District Attorney, bar number 9316, on behalf of Clark County Family Services.
Good morning and welcome.
Good morning.
This is the time set for a hearing on the defendant's petition. The opposition filed by the plaintiff and a reply also filed by the defendant. As it relates to your, and you may be seated.
Oh, thank you, Judge.
As it relates to your petition, sir, do you have anything you want to add beyond what's contained in the papers filed?
Do you want me to make my argument? To some extent, I have to know and have an indication of what the court is leaning towards so I can support my argument or couch it appropriately. Like, have you read the motion opposition?
I've read the papers
Okay.
with the court, and I likely will be issuing a written decision, so
Okay.
I won't make a decision orally here in court. Is there anything that's not contained in the papers that you believe I should know?
No, there are some issues that I would like to address. There was a late filing. It's more of a housekeeping issue, but there was a late filing. Her opposition. I'm not sure what the point of that opposition to my objection was, but essentially it contained within it attachments. There was an interim letter sent by opposing counsel to me. It seemed like it was a motion to strike, but did you see the opposition?
I have not, that just recently came in, so I will take the opportunity to review that before I issue a written decision.
Okay, I don't think it has any bearing because we're here now, and I'm not sure what the point of it was, but I just wanted to highlight to the court that throughout this case, there's been a lot of, this was something that was filed and separately served, yet once again, it's part of my writ petition up in the Nevada Supreme Court highlights this particular issue. It seems like it's an ongoing attempt at ambushing. I'm not quite sure what it is, but I just wanted to note that to the court. Regarding her reliance on the Nalder case, that just the fact that she seems to rely on the NRAP 8 stay and the fact that we don't have any findings for that, which maybe that's part of the reason why we're here. But she also seems to represent in her opposition that the Nalder case represents some sort of complete 100% bar to proceedings. But I don't think that it does that. My objection, the point of that, was to highlight these kinds of issues, just in case I missed something in my reply, because it doesn't represent a 100% bar at all. The court has discretion under Ellis versus Carucci, the 2007, I'm sure you're familiar with the case, but you have broad discretion, and the Nalder case is fundamentally different. It's distinct because this is an issue that's brought forth under Chapter 125C and now because of the ongoing issues. I think I've stood before the court multiple times and I've referenced it in my filings over and over again that these issues, they're not going away. They'll submerge sometime, but they come roaring back, and there's a negative impact on my kids. And because of the fact that the Nalder case is a civil case involving money, it does not represent a 100% bar, and the court can schedule an evidentiary hearing to occur sooner rather than later. She's essentially asking to dismiss without prejudice. I don't think that the court can allow that to happen because the issues are ongoing and it affects the best interest assessment and the welfare of my children. So that's a distinction that I want to point out. Additionally, NRS 432B.290 subsection 6, the statute that I'm harnessing with these ongoing situations It specifically authorizes the release of CPS reports after an evidentiary hearing, after there's an establishment of a reasonable question of bad faith. My petition alleges that establishment of bad faith, and I've supported it. So the issues are well pleaded. I think there was like 6 volumes of exhibits, and I didn't do that on purpose, just by the design of the Tyler system. If you highlight something for convenience of the court, it adds a layer, and then you try to upload it, then it goes from like 11,000 kilobytes to something like 99. So that's why it was 6 different volumes. But did you see the exhibits?
I did.
Okay, so they're substantially backed. The issues are well pleaded. The exhibits that I rely upon, to the extent that she seems to have this continuing argument that these are essentially the same set of facts that are going to go before the court at an evidentiary hearing that's currently stayed. That's not the case, because the issues are ongoing. There's the August 28th, the August 28th incident that ended up, and I understand the delicacy of briefing these issues in a public courtroom setting, and I'll respect that. But where it impacts the best interest of my children, and we'll see where it goes whenever she couches her rebuttals. So I'll respect that out of deference and respect to the court. But the August 28th incident, that's something new. The issues, as I've continually said, they're ongoing and they're well pleaded. There's also scientific publications and video and audio evidence, which if the court thinks that I have not established a prima facie case to even get to, or if that's even necessary, because there is the statutory imperative that the statute says an evidentiary hearing shall, the presentation of evidence will be allowed to occur. So we know that's going to occur at some point. I'm asking that there not be any delay, that it occur sooner rather than later. My writ petition just went to en banc consideration like a week and a half ago, and that's gonna, if they lump her writ for closure into mine, then that's gonna add like 60, maybe 90 days to a disposition. So the time is now. These issues have to be decided. I need access to this report to properly present my case. I do acknowledge that I have limited scope representation, but it's distinct from representation because she's been represented on a series of flat fee agreements. She's essentially retained counsel from 2021. She's been here this entire case, and I'm just finding out about this, the totality of these documents and statements, which highlight what I've been saying all along, that this stuff is ongoing. And the more it gets continued out, the more it becomes the Sims case. You're familiar with the Sims case? The Sims case and those concerns, just the fact that the litigation process in and of itself can be abusive and harmful to the children. All of that becomes more and more relevant. My guy, Mr. Burton, he's there for 1 day. So I've contracted with him for 1 day as the evidentiary hearing, and any extent that this motion or her opposition, which is essentially a motion to dismiss without prejudice, that's the relief that she's asking for. If that's granted, it's default deleterious to the best interest of the children, because I can't give you a complete argument when I don't have equitable access to that document. And additionally, the court with the child custody evaluation that was denied access to me, and then our counsel did not prepare an order on that, so I was essentially left without recourse on that issue as well. So we have the issue of NRS 125-110 at one point blocking access to documents in my cases. The court did not allow me access to the child custody evaluation when I went self-represented, and now we have the fact that I'm just finding out about this on September 10th, the child custody, or not the child custody evaluation, but the CPS report and the statements that were previously covered in heavy redactions. I didn't know that had access to those for more than a year, and I'm just finding out about them. So all of this stuff, if the court decides to dismiss without prejudice, then that's going to be default prejudicial to me, because I can't round out those issues. My attorney's only there for 1 day. It's deleterious to the children's best interest that these matters not be adjudicated. The court has the obligation to just for fundamental fairness and due process and all of that, as you're well aware of what your responsibilities are in ascertaining the children's best interest. But all that stuff is crucial to not just the underlying matter, but to this matter as well. The media's involvement doesn't justify dismissal either, because they've offered their their middle ground solution. You saw their declaration, Your Honor? You saw their declaration?
Everything that's been filed except for what just came in recently.
Okay, so I don't need to brief that.
No,
Okay,
I'm just looking for anything new that hasn't been raised in the papers. Other
okay,
than what was recently filed, and I indicated that I will review that before I issue an order.
okay. So just in conclusion, it's in the best interest of the children that this be heard now rather than later. There's specific authorization in NRS 432B290 subsection 6 and the overarching principles of Nevada law regarding summary dismissal, et cetera, whether it's NRCP 5641, Rule 12, the Buzz Stew case, Myers versus Haskins. I don't think I brought that up in my papers establishing the prima facie case. Nevada public policy is that cases be heard on the merits and allowed to proceed, and that's why we're here.
Okay, all right, thank you. Ms. Wilson, anything you wanted to add beyond what's contained in your papers?
Just a couple of responsive points to this. I want to begin with, well, the first thing I'd like to know is whether or not the media is in fact in the courtroom, because I can only see the courtroom behind Mr. I cannot see the courtroom behind Ms. Latham.
Yes,
Yes, what?
the media is present.
Okay. So I appreciate that was careful to stay away from the specific facts of the case. And so long as we can maintain this general conversation that's not getting into those things, I have no objection to the media remaining. Procedurally, what Mr. was referring to with respect to the most recent filings, the court will observe that my office filed a request for submission and proposed order in an effort to do what I think the court must do in this case at this time, and that is to either dismiss without prejudice this pending, I call it 432B petition for confidential documents, or at least stay that request. Because of the NRAP 8 stay and now what? I'm going to get to the substance of that momentarily, but sticking with the procedural issue, we filed that request for submission and proposed order. Mr. in response filed an objection that is not allowed by any of the rules. I sent a letter to Mr. asking him to withdraw the objection because Ms. does not have the time of her own or ability of her own without the time to investigate Mr. repeated motions and filings, or the money to continue to hire me on an unbundled basis to do that for her. So I asked him to withdraw that improper objection. He did not respond to that letter and proposed stipulation of order. Therefore, Ms. filed she styled it as an opposition to the objection. Mr. refers to this as some kind of an ambush. This is Ms. inability to understand how to file and serve documents on the court. She filed it. When I saw the filing on the court docket, I explained to her she needs to serve it. She doesn't understand the file and serve component of this. So she immediately rectified that within 48 hours. So we would in fact ask the court to simply strike Mr. Objection to the request for submission because it is an improper document. Ms. does not have time to respond to it substantively. And then the court can also strike her opposition to that objection. I think that addresses all of the procedural issues that Mr. raised.
Well, one follow-up question in that regard. recognizing we're here at the hearing today, so the request for some submission on the papers really is moot because we're conducting the hearing today. So really starting with that document, and I'd indicated before, I have not had the opportunity to review the objection or opposition because they came in late. They're late filed documents. You've explained that those are all related to the request for submission, which is really moot by virtue of the fact that we're proceeding with the hearing. So isn't it indeed the case that if I strike any documents, it should be everything beginning with the request for submission, recognizing that that is moot at this point. And then everything after that really follows the filing of that request for summary disposition. So wouldn't it be fair just to simply strike everything that's been filed, beginning with that request for summary disposition, everything thereafter, and rule on the other papers that have been filed?
I think you can do that. The only thing that I would say is that when this case does come back in front of you substantively, I think that Ms. should have reserved the ability to request attorney's fees and costs incurred in connection with having to deal with that improper filing by Mr.
All right, anything else?
With respect to, I think the court well understands this from the opposition that I filed on behalf of Ms. to the 432B petition, and this is in response to Mr. attempted to set forth a rather comprehensive argument about why Nadler does not apply in this circumstance, but it absolutely does. It doesn't have anything to do with the fact that Nadler was about money or this is about child custody. It has everything to do with the fact that when there is an NRAP stay in effect, because the Nevada Supreme Court or Court of Appeals is considering a writ petition, if you bring continued substantive motions to the court, you are necessarily going to find yourself in a case where the dog is chasing its own tail. Mr. 432B petition recites all of the very same facts and issues that are subject of his motion to modify custody, which were the grounds upon which Mr. sought the stay and the writ petition in the first place. So by demanding an evidentiary hearing on the contents of this 432B petition, we are necessarily beginning all over again at the very same spot. So this court really has no option but to do what my opposition said, and that is to dismiss without prejudice or stay Ms. 432B petition. Additionally, substantively, with respect to that, there was a factual representation made by Mr. that I have no ability to evaluate, and I don't know how the court would evaluate it either. His claim that the CPS records to which he has had access are somehow heavily redacted above and beyond the records that Ms. has access to. But the very records that are in my office are the ones that we received from the court in pursuant to the court's order that Child Protective Services produce the records. So it seems to me that Mr. would have access to these self-same records in the court's chambers, or if Mr. Burton, his unbundled attorney, were to request them, they would be the same records to which Mr. has access in my office. And the distinction between what an attorney can have versus what a litigant can have, I think that that's pretty obvious based on the public policy and the court's record, and that might be something that Ms. Latham has something to say about too. I don't know. If the court has no further questions, those are all of the points that I have today.
Notice wasn't imparted upon your agency.
Well,
Is
sort
there
of.
anything?
Sort
Well, I
of.
did see a notice that was filed by the defendant.
Right.
Is
So
there anything you wanted
Right,
to?
yeah, here's the problem with that, Judge. NRS 432B 290 subsection 6 is generally what we practitioners refer to as the release of the reporting source. So when we get something of this nature, we are assuming what they want is the name of the reporting source, which is always redacted for everybody, including the court. So subsection 6 says a person who is the subject of a report of child abuse or neglect made pursuant to this chapter that is assigned a disposition other than substantiated pursuant to NRS 305, and who believes that the report was made in bad faith or with malicious intent may petition a district court to order the agency which provides child welfare services to release information maintained by the agency which provides child welfare services. So it says the petition must specifically set forth the reasons supporting the belief that the report was made in bad faith or with malicious intent. The petitioner shall provide notice to the agency which provides child welfare services so that the agency may participate in the action through its counsel. That's what I'm here to do today, Judge. But our notice was simply the title of the document. He did not serve upon us anything else. We sent him a letter by mail and by email asking that he please give us attachment A, which was his petition, so that we could meaningfully participate, which the statute clearly considers that we have meaningful participation through legal counsel, and he did not respond to the email and he did not respond to the letter. So what I'm here to respond to today, Judge, says notice is hereby given by the named defendant has filed a petition for orders compelling release of confidential agency records pursuant to NRS 432B 290 subsection 6. Attached to this notice is Exhibit A. Exhibit A will be detached upon filing this notice. So that's all I have. I cannot respond to anything else because he ignored our request to please tell us what is it you're looking for? What is it you're wanting? So the first burden is that in order to release the name of the reporting source to this court, we have to know that the investigation was assigned something other than substantiated. So not substantiated information only, something of that nature. I assume we're not talking about one report here because this is personally my second time appearing in this case. So I imagine there's voluminous records. So I don't even know which report does he want us to release the reporting source on to this court. I'd have to go back, I'd have to look and see if those were assigned substantiated, unsubstantiated, or information only to determine whether we even meet the first part of the statute, which is that it has to be assigned something other than unsubstantiated. But the second part of the statute says the district court shall review the information which the petitioner requests to be released, and the petitioner shall be allowed to present evidence in support of the petition. If the court determines that there's a reasonable question of fact as to whether the report was made in bad faith or with malicious intent, and that the disclosure of the identity of the person who made the report would not be likely to endanger the life or safety of the person who made the report, the court shall provide a copy of the information to the petitioner, and the original information is subject to discovery in a subsequent civil action regarding the making of the report. So this statute is extremely specific. It is somebody wants to know who made a report against them that was malicious so that they can then sue them in a civil case. And I'm not even entirely sure that's what any of the parties are looking for, but I can't say for certain because Mr. didn't respond to our request that we be allowed to read his petition. So I'm really at a loss here, Judge, as to assist you with whether or not you should release the name of the reporting source to Mr. because I don't know which report he's talking about. I don't know if he has any evidence that was made in bad faith or with malicious intent. And I don't know if it would be likely to endanger the life of safety of the person who made the report, because I don't even know what we're talking about here.
The identity of the reporting source generally is not included
Never.
in the information that I receive,
Never.
absent a specific order that I would issue.
Right.
So if the issue simply is for this court to release the information that the court has received, that the parties have already reviewed in camera, and it's always made available to both parties and their respective counsel to review those reports in camera without reproducing those documents. If that's the sole issue, do you take a position in that regard? If it's just a matter of the court releasing that information that I have in my file, and we're not talking about asking for additional disclosures such as a reporting source, do you take a position?
I do not, Judge, but with regard to this specific notice that we got under subsection 6, the ask under subsection 6 is to
Is for
release.
the reporting
Yeah.
source.
Yeah,
Understood.
so, and I would have to take a position on that.
Okay. Anything you wanted to add in conclusion?
Yes, Your Honor. I appreciate the district attorney's comments and everything. I don't know what the miscompare is regarding my attempts at service. They were definitively served. They were emailed, served. It was like a seed air and land operation trying to get them the correct documents without me having to actually hand it to them. But I emailed them on October 2nd of 2024 to DAinfo@clark County danv.gov. That was the notice of hearing. That may have been just the notice, but I also simultaneously on the 3rd, I got an email response from them on the 3rd about the notice. They asked for Exhibit A, and that was attached. What I meant when I said that it wasn't going to be attached, it was going to be detached, was that it's following in the mail. So I sent it by certified mail. I have the receipts at my house if the court wants me to file that as a supplemental exhibit later.
The Exhibit A is simply your petition.
It's just the petition. I did consider to some extent the fact that this matter was sealed under NRS 12510. I did not give them the substantiating the 6 volumes of 200 pages of total documents. I didn't give them the exhibits. I just gave them the petition so that they could have fair notice and opportunity to respond, because that's the statutory mandate, as she highlights. But they absolutely got it. I don't know if she personally got it, because I've tried to call them. I don't have her number. I just have a Miss Rose number. I've called her, no answer. Called DFS, no answer. But they were definitively served by U.S. mail, and I can back that up if the court wants me to supplement that. Regarding the identity of the disclosure is known. There was like 3 reporters in this, because what's going on essentially.
Well, so that's not something you're specifically seeking.
Her
understanding
identity?
is you're looking for the reporting source. You're looking for the court to release the records that the court received.
Yes.
So that you have the opportunity to have those records in your possession to prepare for
this case and possibly any
Understood.
antecedent.
But it's not as though you're making a request for this court to make an additional request for the identity of your reporting source.
No, I know that she just self-disclosed it in records on the file. That and any other source, I'm not concerned about. I don't care about
Okay,
the
I just wanted to clarify that.
I did want to clarify some stuff that opposing counsel brought up about the dismissal. So I was correct. It does function as a motion to dismiss. And I just want to highlight again to the court, that's prejudicial to me, because it's going to continue my inability for my one-day representative. It's not reasonable for the court or anyone else to expect that I have to go take off time from work and everything else just to get access into his office and then scrub these 400 pages of documents. It's like 300 from the child custody evaluation, 80 from the CPS report, and create this through line and back build it and apply it properly to the stuff that's already stipulated into the exhibits. I can't expect him to do it because I can't afford it. The fact that she has this digitally residing on her desktop, she can harness leverage technologies and do in-depth analysis. I'm confined to my pencil and piece of paper. And that's obviously, again, grinds against the children's best interest, because you're not gonna have, since he's just representing me for one day, I have got to be able to have the ability to turn him on to these thousands of pages and to make this timeline, because the timeline of when she's saying what she's saying and how it compares to what's going on in court, the timeline is everything. So I have to have meaningful and equitable access, or it's default prejudicial to me, and the job of the court and everything. She's made reference that there are repeated filings. I'm only here because the hilarity is ensuing back home with, she's essentially mandatory reporter shopping and handing copies of documents that she will seed with bad information, and it leads to one terrible result regarding my kids. I mean, my 4-year-old child was recently tested in a heinous manner based on this. So these ongoing issues, the court we've got to get to the bottom of all this, so I have to have the evidence that substantiates what I'm claiming, because otherwise I'm up here looking like I'm crazy, filing a lot of documents. She's asking for fees, but the filings correspond to actual, I would say, mental and psychological abuse that's being perpetuated on the four children, the 2 sibling groups that are being pitted against each other. Because her actions aren't necessarily what the court's seeing inside the 4 walls of this courtroom. It's what's going on outside the courtroom that's compelling me to file these things. And every time I sit down with the documents, I'm finding out new stuff, which just highlights that incongruity right there, that Just by virtue of me being a self-represented litigant and unable to afford, I'm substantially prejudiced to having access to documents in my own case still. She's requesting to strike, and I appreciate the court highlighting that I just want to make sure I understand, your inclination is to strike everything after the reply.
Basically, everything beginning with, there was a request for submission,
Okay.
which is basically requesting that the court rule on the papers.
Right.
Rather than conduct a hearing.
And
that was filed specifically on October 24th. So you're correct, there was a reply, you filed a reply on October 18th. So beginning with that request for submission, I had not reviewed all those papers came in late.
Okay.
And that's what I have not reviewed. And so that's what I would be looking at striking, is beginning with the request for submission. I don't know that I need any
Right.
additional paperwork that either of you filed after that point, because the hearing has
Absolutely.
gone forward.
Yeah, I recognize that the issues are moot, which is why I asked the original question, but to the extent that she's asking for fees due to my filing the objection, if this was an evidentiary hearing or something like that, then I would say that I object to that request, because that objection served an equitable purpose. The purpose was to give notice to the court that if the court was to execute on her request, then it's going to be, again, default prejudicial to me, because you can't consider the four corners of the argument and consider the best interest factors that I'm repeatedly tying everything back to. So I appreciate that, but her request for fees on that is, it's improper, and I don't think that the court should reasonably consider it. As to the fact that I am talking about these documents that are fresh to me and her statements that are heavily redacted, I tried to explain what I think happened. I think that prior counsel, prior to Mr. Burton, I think that there was just the way that I don't think they sought the documents through the court. Mr. Burton has those documents, which is how I found out that, oh my word, I've never seen this before. But prior counsel, I think they got that through the official records inquiry, which means that pursuant to NRS 432B290 subsection whatever, it says that I can, as the alleged offender, I don't have access to anybody else's statements or sources except my own statements to CPS investigators. And that's the document that I got. It was so heavily redacted, with the exception of the ultimate disposition and my own statements to the investigators, that it was the only thing I could discern was that there were no impending dangers, that my children were determined to be safe, so there's no future risk or harm. And I've circled back to that in my papers multiple times because it's the only thing that I can see. Obviously, I know what I told them, but the prejudicial nature of the fact that I'm just becoming aware, it compels that action be taken now, and we schedule an evidentiary hearing so I can show. And if Ms. Latham wants me to hand deliver the documents to her office or give me her contact information later, so I do absolutely acknowledge that they need proper notice and opportunity to be able to see what they want to do. I can hand that to her. I don't think I have the documents now, but I can get that to her. But they have been properly served.
Okay. All right, thank you for your appearances, everyone. The matter will be taken under advisement. I'll issue a written decision. Thank you for your appearances.